Welcome and thanks for attending today's briefing, FBI Guidelines and Racial Profiling in a Post-9/11 World. I'm Praveen Fernandez, the Associate Director of Programs at the American Constitution Society for Law and Policy, otherwise known as ACS. For those of you who are unfamiliar with ACS, we are a national network of judges, lawyers, law students, and policymakers dedicated to ensuring that principles of human dignity, individual rights and liberties, equality, and access to justice enjoy their rightful central role in American law and policy. While our moderator is going to introduce our distinguished panelists, I have the privilege of introducing our moderator, Professor Munir Ahmed. While a true recitation of what he's done will take more time than I have right here, I'm going to give you a Cliff Notes version, secure in the knowledge that you have more complete details in your bio sheets. Professor Ahmed is a visiting professor at the Georgetown University Law Center and a professor of law at American University's Washington College of Law, where he taught immigration and human rights law. Prior to joining the Legal Academy, he was a Skadden Fellow at the Asian Pacific American Legal Center in Los Angeles and a clerk for Judge William Sessions of the U.S. District Court in Burlington, Vermont. His body of scholarship examines the intersection of race, identity, citizenship, and immigration in both legal theory and practice. He is a graduate of Harvard Law School and Harvard College. Without further ado, Professor Ahmed.
Thanks, Praveen. Thank you all for being here today, and thanks to our panelists. The September 11th attacks, whose 7th anniversary will be commemorated this week, ushered in a broad and sustained national conversation about the balance between national security and civil liberties. We saw these issues, this tension between civil liberties and national security, raised in the course of the federal investigation in the immediate aftermath of the terrorist attacks. We saw it at Guantanamo with regard to the rights of detainees, and we saw it in the context of airport security, among others. In each of these contexts, the debate has, to a significant degree, revolved around the question of whether the threat to terrorism can be addressed as a criminal law enforcement problem or whether anti-terrorism is a different kind of beast requiring new and different rules. Today's panel picks up on this debate in the context of federal law enforcement in the post-9/11 era, and specifically the prospect of new and different rules in the form of FBI guidelines being issued next month that would, by most accounts, loosen existing standards and allow the FBI to initiate an investigation, conduct surveillance, or gather data on people in the United States, including U.S. citizens, without a factual predicate of criminal activity. Now, for some, these new guidelines reflect an important step in the post-9/11 evolution of the FBI, from a traditional law enforcement agency to an intelligence-driven agency with significant anti-terrorism responsibility. For others, permitting FBI investigations without the factual predicate of criminal activity raises concerns of investigations and surveillance based on race, ethnicity, religion, or national origin. These are a set of concerns that have been raised by a group of senators in a letter to the Attorney General on this issue. The Senate Judiciary Committee will hold a hearing on this issue on September 17th. In the meantime, to explain and explore these issues further, we have a diverse and distinguished set of panelists here today. I'm going to introduce them briefly in the order in which they'll speak. You have fuller bios on the sheets that have been distributed. We'll start with Joseph Zogby, who is the staff director and chief counsel of the U.S. Senate Subcommittee on Human Rights and the Law, and chief counsel to Senator Dick Durbin, the Senate's assistant majority leader. Prior to this, Mr. Zogby was special counsel on post-9/11 discrimination in the U.S. Department of Justice and senior trial attorney in the Justice Department's Special Litigation Section. Mr. Zogby was also special assistant to the Assistant Secretary of State for Near Eastern Affairs. After Joe, we'll hear from Mike German, who was policy counsel for the American Civil Liberties Union's Washington Legislative Office. Prior to joining the ACLU, Mike served 16 years as a special agent with the FBI, where he specialized in domestic terrorism and covert operations. Mr. German currently serves as an adjunct professor for law enforcement and terrorism at the National Defense University and is a senior fellow with globalsecurity.org. He's also the author of Thinking Like a Terrorist, which was published in January 2007. To Mike's left is Margaret Wong, who is executive director of the Rights Working Group, a coalition of more than 250 community-based grassroots groups and policy organizations committed to promoting the civil liberties and human rights of all people in the United States, particularly in the wake of 9/11. The Rights Working Group coordinates and leads the Liberty and Justice for All campaign, which advocates due process and fair treatment of non-citizens. Prior to joining the Rights Working Group, Ms. Wong served as the director of the U.S. program at Global Rights, an international human rights organization. She's also worked as the program director for Asia and the Middle East at the Robert F. Kennedy Center for Human Rights. We're glad to have here. Rounding out the discussion will be Ilya Shapiro, who's a senior fellow in constitutional studies and editor-in-chief of the Cato Supreme Court Review at the Cato Institute. Before joining Cato, Ilya was special assistant advisor to the multinational force Iraq on rule of law issues and practiced international political, commercial, and antitrust litigation at two firms, Patton Boggs and Cleary Gottlieb. Mr. Shapiro writes the Dispatches from Purple America column for tcsdaily.com and has written for the LA Times, the Washington Times, the Weekly Standard, National Review Online, among many other publications, and we're glad to have him as well. So with that, by way of brief introduction, I'll turn it over to Joe. Each of the panelists will speak for about 5 to 7 minutes. I'll then moderate a brief colloquy among our panelists, and then we'll open up for questions. Joe.
Thanks, Munir, and thanks to ACS for organizing this panel and asking me to be here today. Good afternoon, everybody. I'm a congressional staffer, and we usually like to stay behind the scenes, sort of lurking in the shadows. So it's a little unusual for me to be on this side of the table in front of you all today. I also want to say at the outset that I don't consider myself to be an expert on the issues that we're discussing. So you might be asking yourself, why is he here? And the reason I thought it was important to accept the invitation to be here today is actually has a lot to do with the process by which these new Attorney General guidelines have been created. Congressional staff at this point are the only people outside of the Justice Department who've been briefed on these guidelines. And as a result, I thought it was important to share with you a little bit of our reaction to what we've learned about the process and the substance. And I want to start out with the process and actually focus my remarks there. I think my colleagues are going to get more into some of the substantive details. In the dead of August recess, when, as you all know, Washington kind of shuts down, we were notified by the Justice Department that we were going to be briefed on these new Attorney General guidelines, and that shortly thereafter the Attorney General would sign them, and they would then become operational on October 1st. So we had a couple of briefings with DOJ, and following that, I briefed my boss, Senator Durbin, who's a member of the Judiciary Committee, and he joined with 3 other members of the committee, Senators Feingold, Kennedy, and Whitehouse, in sending a letter to the Attorney General. And I just want to read, I think it's been made available to all of you, but I want to just read a couple sentences from that. Making the draft guidelines available to congressional staff for only a few hours at a time over the course of a week and a half during the August congressional recess, when many staff and members are out of town, does not constitute the kind of meaningful and robust consultation we believe is called for and that might help improve the guidelines. Before you sign the guidelines, we urge you to make them available publicly and to solicit input not only from members of Congress, but also from national security and civil liberties experts outside the government and from affected communities. Now, in response to our letter, as well as a letter from the chairman of the Judiciary Committee, Pat Leahy, and the ranking member of the committee, Republican Senator Arlen Specter, the Justice Department decided that they would, the Attorney General would not sign the guidelines until after a September 17th hearing before the Judiciary Committee featuring Robert Mueller, the director of the FBI that Munir alluded to. We're appreciative of that delay, but it is not clear to us that this will provide the opportunity for the kind of meaningful consultation that the senators have suggested is appropriate in this case. And the reason I say that is because the Justice Department has made clear to us that despite the delay in signing the guidelines, they still will be implemented on October 1st, less than 2 weeks after the hearing. And in fact, the FBI is already being trained on the guidelines. So it is unclear to us that there actually will be an opportunity for meaningful input that could lead to changes in the substance of the guidelines. Now, I should say it is important to note that the Justice Department has the authority to issue these guidelines and has the authority to do so without consulting with Congress or anybody else, experts or affected communities. But saying that they have the authority to do so is a very different thing from saying that it is appropriate or productive towards their counterterrorism efforts. And I say that because of the particular climate in which we find ourselves, when there is an atmosphere of mistrust, particularly in communities that have been most affected by the Justice Department's counterterrorism efforts. And this sort of, is a fundamental precept of community policing, that you've got to build that trust in order to be effective in working with the communities that you're focusing on. And I think that the issue of trust and mistrust is even more pronounced in light of the timing of these guidelines. October 1st, in the last year of 8 years of the Bush administration. The timing has raised some questions for members of the committee. We asked at a staff level, why October 1st? Why is this date so important? And we really didn't get a persuasive answer as to why it had to be now rather than in a new administration. So my colleagues, as I said, are going to probably touch more on the details, but I do want to make just 2 points as somebody who's actually spent some time with the guidelines, because I think there's been some misinformation circulating. One is on the issue of assessments. The guidelines authorize the use of so-called assessments without basically allowing the FBI to use some surveillance techniques on innocent Americans with no indication of wrongdoing on the part of the target. And the Justice Department has said there's nothing new here, that assessments have been authorized by the Attorney General guidelines in the past. And that is true. In 2002, Attorney General Ashcroft signed revisions of the guidelines that permitted the use of these assessments. And I guess I'd make 2 points on that. One is that this was controversial at the time in 2002, and there was criticism of the assessments, both from the perspective of civil liberties concerns, potential civil liberties concerns, and also in terms of whether or not this was a wise use of FBI resources. And whether or not it could lead to the FBI chasing down some blind alleys instead of using what had been the case in the past, having to have a factual predicate for beginning to look at somebody. And the second point is on profiling, because there's been so much discussion about this. And it is true, as the Justice Department has said, that the guidelines don't explicitly authorize the use of profiling. What they say is that the FBI is required to comply with the Justice Department's rules on the use of race. And that is true. But that is not the same thing as saying that profiling is prohibited. And it seems clear to us that the guidelines would allow the use of race, ethnicity, and national origin as the basis for assessments or investigations. And I say that in part because the Justice Department's rules on the use of race allow the use of race, national origin, ethnicity, and religion in national security investigations. And so I'm sure there'll be more discussion about that in the course of the panel, but I wanted to make those 2 points at the outset, and I'll stop now and look forward to the discussion and questions. Thanks.
My name is Mike German. I'm Policy Counsel to the American Civil Liberties Union's Washington Legislative Office, and am interesting because I'm kind of the opposite. I actually worked under these guidelines, so as an FBI special agent, and know quite a bit about them. Kind of my role in 5 minutes is to give a quick history of what the guidelines are and why they're important. one of the first things to understand about the guidelines is that they weren't developed just, as the FBI developed, that it actually was a product of abuse, that during the 1950s and 60s when the FBI was using its law enforcement and intelligence collection powers illegally against political opposition, against activists, against civil rights leaders. Congress took notice of that and started pursuing options for legislative reform of the FBI. And the Attorney General at the time, Edward Levy, decided that he would promulgate internal guidelines to forestall any outside legislation that would either provide the FBI an investigative charter or limit the use of particularly intrusive investigative techniques. And basically the manner that Attorney General Levy took was to, which would sort of make sense for a law enforcement agency, to try to limit the FBI's activities into matters where law enforcement was necessary, i.e. where people were actually violating the law. So it created a very simple standard that the FBI could not initiate a full investigation of somebody unless there were facts and circumstances that reasonably indicated that somebody was engaged in illegal activity. Seems like pretty much a no-brainer. And as an FBI agent training younger agents, I would often say to them, it's pretty easy to work with standard unless you're walking into the office every morning and picking up a telephone book and picking out somebody you're going to investigate. You usually have a reason why you think this person is doing something wrong, and if you simply articulate those reasons, write them down, that will usually amount to reasonable suspicion. And it's just a matter of making sure that you do have articulable facts before you proceed with an investigation. Now, of course, there are often times in law enforcement where there are pieces of information that don't amount to those facts and circumstances that would give a reasonable person to believe. And the Levy Guidelines acknowledged this and authorized preliminary investigations and limited investigations. And basically the purpose of these investigations was where there was some smoke, but you didn't yet know whether there's fire. So it gave law enforcement an opportunity to reasonably look into whether the smoke is actually part of a fire. And he was very careful in those areas to limit both the amount of time, they were limited to 90 days, and the types of techniques. So if there wasn't enough to indicate somebody was actually involved in or planning future criminal activity, the FBI couldn't unleash all of its authorities against that person. That doesn't make sense either from a civil liberties standpoint or from a use of resources standpoint. I mean, if we don't really know yet whether this person is doing anything wrong, why would we, set up a huge undercover investigation to go find out? It's much more realistic to do sort of limited checking of leads in order to then decide whether a full investigation is warranted. The Levy Guidelines did forestall any legislation, so there hasn't been legislation coming out that has limited the FBI's use of techniques or otherwise circumscribing its activities. The guidelines changed considerably over time, both in the actual style of the way the guidelines were written and the authorities they covered, but also in the number of guidelines issued. And I think that's something very important to recognize as we talk about these changes in guidelines. In 1980 and 81, Attorney General Civiletti issued separate guidelines on the FBI's use of informants and the FBI's use of undercover techniques. Obviously, two very intrusive sort of techniques. This actually came on after the Abscam case, where the FBI's use of undercover techniques was very prominent, and people were concerned that, without proper guidelines, this could easily be misused and abused. And then later on, under Attorney General Smith, there were new guidelines created for foreign intelligence collection, and this is really what I think is most important with the changes to the new guidelines, because the FBI has dual roles. The FBI has a criminal law enforcement role and also has a national security role to protect against foreign threats. Now, clearly, those are two very different types of activities, and the FBI is usually divided in two separate houses that conduct those separately because the types of techniques they're allowed to use, things like national security letters, which people have become familiar with over the last couple of years, and Foreign Intelligence Surveillance Act, as opposed to criminal search warrants, criminal wiretaps, and other sorts of law enforcement techniques that we're used to watching on TV. These techniques require a much lower threshold of proof in order to authorize the FBI to conduct investigations. So just the fact that a person is a foreigner often allows the FBI to start doing an investigation. So you can imagine if that's the case, the FBI would want to have internal guidelines that would then limit the amount of techniques because, again, it's a resources decision where do we want to, you know, set up a whole undercover operation or recruit informants to go out and collect information on every foreigner? Of course not. That would be a waste of resources. Only when there would be a reasonable cause of that would the FBI get engaged in that. Well, that's where I think the Attorney General has been somewhat, I don't know how to say it exactly, that I think you should examine his language carefully where he talks about harmonizing these various guidelines because they actually cover very different types of investigations. And if you harmonize them in a manner that simply waters down the protections on each side, you're actually diluting protections for Americans. And I think that was pointed out in the letter where it talked about the FBI's authority to collect foreign intelligence and how that might affect Americans rather than just foreigners. Not that that shouldn't be a concern for foreigners as well, because again, the idea is that if you restrict the FBI to focus on people they have a reasonable belief for doing something wrong, it's much easier for them to actually get the right people and not be wasting a lot of time on the wrong people. The Attorney General Guidelines most recently changed in 2002, as was previously said, and where the change was particularly significant was in expanding both the length of time and the types of activities that could be conducted under a preliminary inquiry. And that, again, is the stage of the investigation before the FBI has reasonable indication that somebody is involved in some sort of criminal activity. And that's, of course, very dangerous because where the FBI has not really got, you know, in fact, it expanded the time from 90 days to 180 days for initial preliminary inquiry with two 90-day extensions. So basically for a year, the FBI could investigate you without knowing, without having a reasonable indication that you're doing something wrong. And just to finish up, sorry, I run out of time, is that the problem with all of these is oversight. That, you know, there was a 2005 Inspector General investigation audit of their compliance with the Attorney General Guidelines, and they found, for instance, in the confidential informant guidelines, that 87% had one of the files they examined had one or more violations of their internal guidelines. For the FBI's preliminary inquiries, 53% had gone beyond their 90-day authorization period, and 77% were reauthorized without the appropriate information in the files. So, you know, that's really the biggest concern here, is that we're giving the FBI this extended authority. They're now wanting to extend it even further, and they're not following their own internal guidelines, and that's something that should be a concern to all of us.
Thanks. Thanks. I'd also like to echo my colleagues in thanking ACS for inviting me to join this panel, and I'm delighted to be here. As Munir said, I'm Margaret Huang. I'm the Executive Director of the Rights Working Group. We're a coalition of more than 250 organizations from around the country working to protect the rights of people who've been particularly targeted by national security policies, including immigrants, including Muslim, Arab, and South Asian groups, including African Americans and Latinos, and many of the groups, I'm happy to say, are actually in the room today. So I'm delighted to see our members here as well. My role today is to talk about our concerns over the proposed changes to the Attorney General Guidelines, as well as other recently proposed rules and regulations that will result in profiling based on race, religion, ethnicity, and national origin. And I want to make 3 points today. First, profiling is an ineffective tool for law enforcement. Second, profiling targets those communities that are critical stakeholders in our government's efforts to combat terrorism and other national security threats. Third, profiling in addition to being ineffective, is a violation of our constitutional and human rights, and we should be working to end racial profiling as opposed to promoting it. So let me start by talking about profiling as an ineffective tool. History has shown that when an investigation is based on a person's race or ethnicity instead of on suspicion of criminal behavior, the pool of suspects under investigation increases, but the success rate of investigation decreases. So I have a great example from law enforcement agencies' efforts to create a drug courier profile. This was intended to identify a set of characteristics that guide officials in deciding who to stop for suspicion of carrying drugs. Now, these profiles have also not been publicized for fear that a savvy drug courier might be able to disguise themselves in an unsuspicious way. But researchers have combed through police testimonies in courtrooms across the country and have compiled a list of the criteria that law enforcement agents have actually used to identify suspects. And I want to share just a short list of some of these with you. The suspect arrived late at night. The suspect arrived early in the morning. The suspect arrived in the afternoon. The suspect bought a coach ticket. The suspect bought a first-class ticket. The suspect carried no luggage, carried brand new luggage, carried a small bag, carried a medium-sized bag, carried 2 heavy suitcases. The suspect traveled alone. The suspect traveled with a companion. The suspect acted too nervous. The suspect acted too calm. The suspect walked quickly through the airport, walked slowly through the airport, walked aimlessly through the airport. With such a profile, how could anyone not fit in? Rather than facilitate effective enforcement techniques, these kinds of profiles serve as an excuse for law enforcement to stop whomever they want to stop, as opposed to who most likely is a reasonable suspect. My second point, the U.S. is targeting those communities that we actually want to engage in our national security efforts. Singling out a particular group based on their race or religion violates the Equal Protection Clause of the Constitution, but it also dramatically increases the potential for further human rights abuses. The massive roundups of Arabs, Muslims, and South Asian men after 9/11 was done in the name of fighting terrorism and promoting national security, but there was little practical effect. Out of the more than 1,200 men who were detained in those months after 9/11, only 3 were charged with terrorism-related offenses. Only 1 was convicted, and that conviction was later overturned for prosecutorial misconduct. Another good example, the Bush administration's discredited national security entry-exit registration system, the NSEERS program. In 2002 and 2003, the program required men from 25 predominantly Arab and Muslim countries to register with local immigration offices. More than 84,000 men and boys complied and registered with the immigration agency. Not a single terrorism prosecution resulted from the program, although 13,000 men were deported for actually complying with the request. The NSEERS program alienated tens of thousands of men and boys and their families, who, unlike millions of other non-citizens in the United States, had to register out of an unsubstantiated fear that among them might be terrorists or someone connected to terrorism. It also corresponded to increased hate crimes targeting these communities by reinforcing xenophobic attitudes about certain immigrant groups. Lastly, profiling is a violation of our Constitution and our human rights. Let me quote President Bush in February of 2001. "Racial profiling is wrong, and we will end it in America." Or John Ashcroft in February of 2002, then the Attorney General. "This administration has been opposed to racial profiling. Using race as a proxy for potential criminal behavior is unconstitutional, and it undermines law enforcement by undermining the confidence that people can have in law enforcement." Law enforcement practices that focus on race and religion have a chilling effect on First Amendment rights, those rights that the founders of this country fought and died for, the right of freedom of expression, assembly, and religion. When authorities employ such practices as the once proposed mapping of mosques in Los Angeles, people will be scared to exercise those fundamental rights, like the right to worship. Those communities may be less likely to participate in political processes, community organizing, or open dissent for fear that they will open themselves to further investigation. The Bush administration has long set up a false dichotomy between security and rights. The rights that have long been enshrined in U.S. and international law are not a threat to national security. Rather, they're the only protection that vulnerable populations have against unlawful state interference with their constitutionally protected activities. With recent revelations of domestic spying on a wide variety of community groups exercising their free speech rights on topics such as the death penalty or opposition to the Iraq War, the dangers of such broad profiling and unrestricted investigative powers are clear. They target legal activities while distracting law enforcement from actual criminal activity, and they don't increase our security. We hope that the Department of Justice will undertake much broader consultations with civil society about these new proposed guidelines and make revisions to ensure that profiling based on race, religion, ethnicity, or national origin is effectively banned in all law enforcement investigations. Thank you.
Well, I also would like to thank the ACS for inviting me to be here. I've been to the National Press Club several times, most often I think for Federal Society events, and never did I think that the first time I'd actually appear on a panel here would be for an ACS event. So I'd like to thank my former colleague, Praveen Fernandez, we worked together at Patton Boggs for having me here. And it's an interesting group. I've learned a lot already. Of course, we range the gamut from civil libertarians to libertarians. I kind of feel that we need someone who's a law and order conservative here to round it out. But I'll do the best I can. Having said that, that means if you're expecting a red-blooded, red-meat defense of racial profiling and all sorts of law enforcement excesses, I'm sorry, I'm going to have to disappoint you on that. I'm here to kind of provide a voice of reason. I'm neither a former FBI agent. I've never been working under these guidelines. I'm not a congressional staffer. I haven't been briefed on them. I'm not involved in those processes. In fact, when Praveen first invited me to do this, I was thinking, well, okay, the event is September 9th. The release of the guidelines has been delayed. What are we going to be talking about? We don't actually know what the guidelines are. Interestingly enough, I found just about a month ago, Attorney General Mukasey gave a speech that I commend that all of you look at if you're interested in these issues in Oregon, August 13th. You can Google it or look at it from the front page of the DOJ website that lays out the rationale for why the guidelines were under review, what kind of changes are being put in, and all the rest of it. And Joe and Mike can correct me who know more about the specifics of these issues, but it seems to me that this is a pretty detailed and less controversial change than some of the news reports that have come out, both when this first broke the mass media in early July and in recent weeks when they announced that they would be delayed and they would have this hearing and so forth. But again, the proof is in the pudding. As any good lawyer, I have to issue my disclaimer. I mean, all of us, or I at least, am speculating about what is going to change with these guidelines, and it's tough to comment on the specifics. So I will just talk about general principles of, if this is put in, that would be good. If this is put in, this would be bad, and so forth. I agree with Margaret that racial profiling is unconstitutional and ineffective. And the guidelines, nobody disputes that the guidelines can somehow do something or allow law enforcement to do something that either statute or the Constitution prohibits. My colleague Jim Harper wrote a paper that is out in front that you can pick up, a Cato policy analysis on data mining, which is kind of a sophisticated way of predicting who is going to be a security risk. And even he provides this one case study that a specialist, an information technology specialist, after 9/11 tried to recreate and find some of the 9/11 terrorists by inputting all of the particular factors that would a predictive data miner would use, and still, even knowing the profile, after 9/11, in that kind of atmosphere, there was still a 99% false positive. So out of, I think he finally narrowed it down to about 500 people, and 5 turned out to be among the 9/11 terrorists. So not only is that ineffective, but it's a waste of resources. We can certainly be going about these in different ways. So I certainly would not be arguing that we need new methods to combat with terrorism after 9/11. It's more a matter of, as the 9/11 Commission detailed, using existing methods in better ways. That means better investigations, better communications and collaboration among different law enforcement, and especially within the FBI. I mean, we hear about the competition and turf wars between intelligence agencies, FBI, CIA, whatever, but that as well needs to end and to be more effective, but for us to be more effective in counterterrorism, but especially within an agency, within the FBI. And I think that's what the guidelines are meant to do. Or again, as I said, if that is what they're doing, and if that's their purpose, and the steps that they take do that, that is good. But again, if it relies on predictive data mining rather than data analysis, and using existing methods in smarter ways, then it's both not better counterterrorism and worse in terms of civil liberties. What I would also say, though, is while racial profiling, let's be clear, by saying that racial profiling is ineffective, I mean that starting an investigation using as a factual predicate the fact that someone is Muslim or black or what have you, that's not smart. I mean, it's a violation of civil liberties, and it's not smart and effective. But ignoring characteristics like that is also not smart. I mean, again, the proof is in the pudding of how you aggregate all the different things that you're looking at. When police get a report about a bank robbery, and they say that the suspect is between 5'10" and 6 feet tall, is wearing a blue sweatshirt and is white or tan or however you want to describe him, stopping everybody regardless of whether they're wearing a blue sweatshirt or not, regardless of whether they're white or not, is ineffective. Similarly, we have to recognize that the terrorism that we face since 9/11 is exclusively pervaded by Muslim groups. And what that means, I don't know. I'm not a law enforcement specialist, but presumably the people that are smarter than me, Mike and his old friends, know how to use that information. And for example, there might be an informant that tells you that X person traveled to Afghanistan. Another informant or business records tell you that he also took scuba training. Another informant or records or some other type of data tells you that this person took weapons training or legally bought a gun of some sort. When you aggregate these pieces of data, again, these are not new methods, but in newly collaborative ways, perhaps, hopefully, they might be able to get you to new conclusions, just like we have suspicious activity reports in banks for money laundering purposes and so forth, and terrorist financing. So I think I'll leave you with an example that all of you are familiar with. I just flew in from Miami this morning, and all of us hate going through airport security, and everybody has to take off their shoes, and you can't carry a liquid like this, even though it's proven that you can't have, if you have two liquids like this, no two liquids combining them would produce any type of explosion or damage to an aircraft. Why do we do this? I'm not exactly sure. And we see, blue-haired octogenarians being screened in infants rather than, just take young men. Young men between the ages of 18 and 35, say, commit, I don't know what the exact statistic is, but it's 90% or whatever of all crimes and terrorism and all the rest of it. So even by limiting your searches to that age group, perhaps would be a better technique. I don't know. I just don't want anything to be taken off the table. So as a good libertarian, I want the government to be doing what it's doing to be smart, and neither to be, if they're going to be violating civil liberties or somehow doing things that make us squeamish, at least have an improvement in the counterterrorism results. And I'll end with that.
Thank you. Well, I want to thank all the panelists for their informative presentations. What I'd like to suggest is that we spend about 15 minutes or so. I'm going to try to engage the panelists in some issues, both of commonality and difference as I heard it, and then we'll open it up to the floor. Where I'd like to start is in some respects where you ended up, Ilya, and it's both a point of commonality, but also I think a point of what I heard to be some perhaps significant divergence around racial profiling. So the point of commonality is there seems to be down the line a general belief that racial profiling is both unconstitutional and bad. Bad as a matter of policy, bad in terms of its efficacy. But as we start to pick a little bit deeper, I wonder if we're all talking about the same thing when we use the term racial profiling. So I want to ask a couple of questions to try to get at that. The first question, to step back a bit, assuming that the new guidelines do remove the requirement for a specific factual predicate of criminal activity, does it necessarily follow that in the absence of the requirement of a specific factual predicate, that FBI agents are going to rely upon profiling? Which is to say, just because there isn't now this requirement for factual predicate, what is it that leads us to the conclusion or the fear or the suspicion that the practice is going to be one of profiling? So that's the first question I wanted to put out, and whoever would like to take a stab at that. The second related question, picking up on where Ilya left off, is given the realities of contemporary terrorism practices as we've experienced them in the last 7 years, is it perhaps not justifiable for the FBI to base its investigations and surveillance, at least in part, if not exclusively, on race, religion, ethnicity, national origin? Does that make sense? And might that partial reliance on race, ethnicity, and so forth pass constitutional muster? So there's a cluster of questions there. Margaret, do you want to start us off?
Yeah, I'd love to. Thanks. In response to the first question, would the FBI have to resort to racial profiling? I mean, I think the best example is to look at what happened after 9/11. The FBI and others didn't go out and look at people who had been taking flying lessons, regardless of race. They went out and rounded up Muslim, Arab, and South Asian men. And the way that they found them were through tips. Somebody said, I saw a group of men riding in a van. Go pick them up. It had nothing to do with any actual predicate of criminal behavior. So I think at a certain level you're asking, well, can't we trust that their good judgment will guide them into not racially profiling, but that they'll follow their criminal investigative techniques. And I think the reality is that when terrorist incidences have happened, we've seen that they have in fact resorted to racial profiling. In terms of what the problem is with racial profiling, I actually saw an article this morning from NBC News noting that there have been arrests of 3 Germans of Germanic descent, 3 white guys from Germany who have been arrested for being trained in al-Qaeda camps. Now, they're not going to fit in any of the profiles that we're using right now. And if they got on a plane and came to the United States, they would not be stopped. So that's the problem with using profiling. It doesn't actually lead you to the people who might be doing something wrong. It instead leads you astray and wastes your resources looking at people not looking at the right people. There's a great example from the Mckinley assassination when a white man carried a gun in to, I think it was the Pan Am event, exposition, and shot the president. The Secret Service agents were looking at the African-American man behind him, who turned out to be a former police officer who actually knocked down and held the guy who shot the president. But because they didn't check other people, they only checked the guy that looked suspicious based on his race, they missed the opportunity to stop that assassination. It's a long time ago profiling event.
The thing is we have data, and there have been studies about racial profiling, and I think that's one of the things that is really most troublesome to me about this is that I believe the FBI and the Department of Justice and state and local law enforcement have done a very good job over the last 20 years convincing the rank and file through evidence that racial profiling is not effective and that it actually causes more problems than it solves. So, rather than just imagining that maybe it could work, we can actually look at data. There are all sorts of studies about predictions of future dangerousness that we can look at. And what we find is they're not very good. We aren't very good at predicting what human beings are going to do. And what I've said often when I speak on data mining issues in law enforcement, if they really had data mining programs that could predict the future dangerousness of people and predict the future, they wouldn't be selling it to law enforcement. They'd be selling it on Wall Street, and they'd be selling it in Las Vegas. The fact of the matter is, if you pick up any mutual fund prospectus, it has that little disclaimer at the bottom. Past experience does not indicate future behavior. We can't predict the future, and the idea that we're investing all these resources into this system that we know is going to produce false positives that are going to impact the rights of innocent people and also waste law enforcement resources in incredible numbers. And the perfect example is the watch list, where there's a USA Today story that came out about a month ago about how state and local law enforcement officers are no longer waiting for the replies once they get a watch list hit. And it's perfect false alarm studies. And the Defense Department has studied false alarms for a long time. You can go look at their evidence. If you set up false alarms, that will reduce people's awareness and reduce their interest when they have an alarm, because they know every time I've had a hit on the watch list, it's turned out to be nothing, and I waste an hour and a half of my time and make this person very irate. It's not worth my time. I'm going to just let them go. Right, exactly. It's exactly what it is. So we know this is ineffective, and yet the government is proceeding full pace, and we do know that they're engaged in data mining. They issued a Department of Justice under the Patriot Act reauthorization. They had to issue a report on their data mining activities, and that report came out in July of last year, I think. So, it's an ineffective model, and rather than keep wasting resources thrown at this, we really have to get in. And if they can't prove it's effective from the very beginning, we shouldn't even put a single dollar into it.
Now, what is effective is something, again, I'm going to use the airport example. I don't know how many of you have flown to Israel, but when you go through a screening, especially on El Al, but also by Israeli agents working for other airlines, they question you, and they look at not just your response to different questions, but how you react, and they're all trained in psychological profiling and whatever else. That seems to be a smart procedure. Is it more intrusive than the norm? Well, yes and no. It seems to make more sense than having everybody go through the same thing and, as I said, randomly screening people. So you have grandmothers and toddlers being screened, and people who are those are the extreme examples. But who knows? It's certainly a randomized counterterrorism system is probably worse than no system at all. And so you have to play probabilities and statistics in certain respects. In the acute example of boarding an airplane, that's a little different than a long-term counterterrorism investigation program. So the analogy breaks down. But what I'm trying to say is that when these factors, and we can define what racial profiling is, when you go through these, it depends what you're looking for, and when you go through a criminal investigation versus national security investigation versus just intelligence gathering, there's different criteria that you use, different factors that you use, and you weight them differently. So under certain circumstances, data mining generally is not a good idea, but under in specific times when you're looking to lower risk, you play statistics in a certain way.
I just want to make one quick point on this. I think it's precision of language is very important here, and what you mean when you say racial profiling it varies significantly, I have found, when people talk about racial profiling. I think the best standard is actually the one that the Justice Department has adopted for what they call traditional law enforcement. And that standard is that race, ethnicity, national origin, religion may not be used to any degree, except in the so-called suspect-specific situation. In other words, when there is a description of a suspect. And Ilya gave some examples in his presentation, which I think we all would agree. If there is a description of someone who's committed a robbery, a white man wearing a red hat, of course law enforcement needs to take race into consideration in that case. They have a description. The question is, when you move beyond those suspect-specific situations, in that case, does it make sense? And the Justice Department, under this administration, has reached the conclusion that in the context of traditional law enforcement, it doesn't make sense. It doesn't work. It's ineffective. It alienates communities. Then, for some reason, they, in the context of national security, create an exception, a carve-out, where that standard does not apply. And the question I think we all need to ask ourselves is, does that make sense? Or do the same concerns that pertain when it comes to traditional law enforcement, alienates communities, wastes resources, doesn't work, do those apply in the national security context as well? I think they do. Senator Durbin thinks they do. And so that's one of the questions these FBI guidelines pose to us, because they adopt the DOJ guidelines on the use of race. And just one other point, I'm not an expert on airport profiling, but before you reach any conclusions about the Israeli airport system, I'd encourage you to talk to some Arab Americans who've gone through the airport there and ask them whether or not they think that there's any racial profiling at work there.
Oh, there is, but I mean, I'm arguing that in that circumstance, it's justified. It's not in terms of profiling; it's in terms of using, whatever factors are more indicative of what's relevant to you. And just piggybacking real quick on what you said, certainly there's a distinction between criminal justice and law enforcement and national security. Even if the investigations looked the same or the methods are the same, for criminal justice purposes, the goal is different, is to convict somebody. For national security, is to prevent attack. So even if a given method, we wouldn't allow the fruit, the evidence of that, to go towards a prosecution, we wouldn't allow it in court by our rules of evidence, we would still want to use that method under circumstances. Again, I'm speaking in hypotheticals, just bear with me. In general theory, we would want to still use that method for purposes of deterring attack. And there are different standards to be used. What Attorney General Mukasey points out in his speech, which again I assume makes it into the guidelines, is that there shouldn't be separate type of paperwork or different types of agents that are under investigation and somehow switches from criminal justice to national security to intelligence and back have to all of a sudden report to different people or fill out other paperwork or what have you. It's just the end result of the investigation, its purpose is different, even if the methods might be the same.
Just very quickly, sorry. And my point is actually not to what is legal or what evidence might be admissible. It's really more about what is effective and what's right, what's just in a society that aspires to protect the rights of all individuals, regardless of their race, ethnicity, or religion. And that I think pertains whether it's in a cop pulling over somebody on the side of a road or in the Israeli airport pulling somebody aside. So I'm actually not so much making a legal argument here.
So let me put out one more question, and we'll do a round, and then we'll open it up. So, Mike, one of the things I want to direct this in the first instance to you, and then open it more broadly. But one of the concerns that's raised, and Ilya alluded to this, and it's raised in the letter from the Department of Justice in response to the senator's letter, is that you essentially, you described the FBI engaged in essentially dual role: law enforcement, criminal investigation, and national security. The letter describes three: law enforcement, national security, and foreign intelligence. Now, you expressed a skepticism toward the notion that these are going to be harmonized. If I understood you correctly, what you're saying is that what that may end up doing is applying the lowest standard across all. So the first question in this regard is, first of all, do you think that agents are, in fact, confused by the fact that there are two or three different roles that they're asked to engage in, and for that reason there's a need for some clarity. Because that's one of the rationales that's put out there. The harmonization is intended to provide line agents with greater clarity on how to perform their job. I suppose that the larger question I want to raise with the group is that here again, I heard general consensus that this isn't about coming up with new rules, it's using existing methods more smartly, more intelligently. But I wonder, isn't there a way, I mean, to take Ilya's point, if the end goal of a national security investigation is prevention rather than prosecution, it seems to me this dovetails with the Mosaic Theory, right? That we don't necessarily know what information is important until we know lots of information and we can start to build connections between it. And so forcing us into this narrower rubric of solving crimes isn't giving us the tools that we need in order to deal with the threat of terrorism. And so I wonder if you believe down the line that the existing tools are enough, or whether, in fact, there does need to be some rules change. It's not just about applying the rules more intelligently. It actually is about loosening the reins so that the FBI can do more. So if we can start with you, Mike, on what the line agents need or don't need, and then broaden into the...
Sure. I need more than 5 minutes on this. You know, I mean, go back to the beginning. If you look at the 9/11 Commission report and the Joint House-Senate Intelligence Committee investigations, among all the intelligence failures that allowed 9/11 to happen, not a single criticism of a law enforcement technique or a law enforcement officer. In fact, it was the law enforcement side of the FBI, agents investigating the embassy bombings in Africa and the Cole bombing, that actually had the bits of information that the intelligence community used to track al-Qaeda terrorists overseas. The intelligence community gathered a lot of information based on the information provided to them from those criminal investigations and did not pass it back to the criminal investigators. There was actually an investigator investigating the USS Cole bombing who several times asked for information relative to two of the hijackers who the CIA knew had visas to come to the United States, and the CIA didn't give them that. So part of the problem is that we've enabled the side of our national security apparatus, the intelligence side versus the criminal justice side, that is least effective. And the reason they're least effective is because, as the Joint Senate House Senate Intelligence Committee investigation said, the significant pieces of data were lost in the vast streams of data being collected. That where they are so spread out, collecting all sorts of information without any sort of reasonable cause, it's easy to lose the pieces that are actually effective. Where criminal justice methods track you from not logical lead to logical lead, known bad guy to known bad guy, and if those methods were empowered, I think we'd be far more successful. I mean, I worked on the criminal justice side, and I worked domestic terrorism cases, you know, which are the most sensitive. I mean, that's what we're most concerned about. And I was able to work those effectively using the old guidelines without any problem. And in fact, I felt they helped me. So I think that's the clarity that's needed. And where what's not needed is a lack of clarity. And that's where these guidelines are going. And if you look at the Ashcroft Guidelines as an example, you know, one of the sort of linchpins that's even in Mukasey's statements is, you know, we will not open an investigation based solely on First Amendment protected activity. But here's what it actually says in the Ashcroft Guidelines. It's important that such investigations not be based solely on activities protected by First Amendment or lawful exercise of any other rights secured by the Constitution or laws of the United States. When, however, statements advocate criminal activity or indicate an apparent intent to engage in crime, particularly crimes of violence, an investigation under these guidelines may be warranted unless it is apparent from the circumstances of the context in which the statements are made that there is no prospect of harm. Well, I would tell you there's never a time when you can say that there's no prospect of harm. So this actually creates that lack of clarity that makes it hard for agents to know what am I allowed to do and what am I not. And if we simply look at the National Security Letter Authority that was expanded under the Patriot Act, we can see how lack of clarity, you know, gave everybody free rein to start going out and collecting information on people 2 and 3 times removed from subjects of investigations. And look at the results. You know, the IG only pointed to one terrorism-related prosecution and only a handful, I think it was less than 200 criminal prosecutions overall. And as much as it's easy to say prevention is the goal, how do you prevent a terrorist who's in the United States from committing an act of terrorism if you don't prosecute him? You're going to deport him? You know, because these rules were built for the KGB. That's why we built these national security rules. And a KGB agent, you could tap him on the shoulder and say, hey, buddy, we know you're KGB, go home. Here's your PNG status. You can't do that with a terrorist. And if we're just deporting these people, if we're just, you know, particularly where there isn't a trial, where there's evidence presented, where everybody is satisfied that that person has done something wrong and deserves this type of treatment, it gives them a huge propaganda victory and allows them to treat each one as a victim, even where there might have been evidence that's being kept in secret. So sorry to go on.
Yeah, thank you. Let me just ask, is there anyone else who wants to weigh in briefly on this? Okay. In that case, then I'm going to open it up and just a couple of housekeeping rules. We've got 2 microphones that will make their way around. So if you can just wait for the microphone to be passed to you before you start speaking. Second, I'm going to ask if we can start with members of the press, since we are at the National Press Club. And third, if you can identify yourself when you speak. So members of the press first. Start in front.
Hi, I'm Penny Starr with CNSnews.com. My question is for Margaret. Well, first, overall, I can't figure out how you can be commenting on guidelines that you haven't seen. That's one thing. And two, it's interesting that we brought up that if the authorities know that the bank robber is wearing a certain thing, is of a certain race, then obviously we're going to look for a Caucasian in a certain outfit of a certain height, et cetera. Mm-hmm. Well, in the case of 9/11, we knew that it was Muslim men who had perpetrated this attack. So why is it wrong that we would use that information to try to catch bad guys? And moreover, you've talked a lot about how racial profiling does not work. Well, what does work? What can we do? Do you have answers about what we can do? Because the bottom line, I hope we all agree, is to find the bad guys.
Great. Thank you. I hope I'll get all of those questions. Sorry, I should have been writing them down. First, how can we comment on guidelines that we haven't seen? Well, I agree it's actually a problem that we haven't seen the guidelines, and that we won't be able to see the guidelines most likely before they're put into place. But I think it's clear from the changes that were made in the 2002 guidelines, as well as from other new rules and regulations that have come out, changes that have been made to other guidelines affecting law enforcement, that there is a push to encourage these kinds of changes where profiling is going to be allowed. And so we've also heard from Attorney General Mukasey about what his expectations are and about eliminating these rules about not using profiling. So I think it's clear that we can expect they're going to have those kinds of changes in them. And we hope that we would have the opportunity to review them so that we could offer more explicit and constructive feedback to the Department of Justice. Why shouldn't we have profiled Arabs and Muslims if we knew that those were the people responsible for 9/11? Well, if we knew that there were a group of white men who had run planes into the Twin Towers in New York, would we have gone out and arrested hundreds of thousands of white men? It's not a strategic use of law enforcement. I mean, the entire purpose of this is that race alone can't be a determinant for effective criminal enforcement.
What is effective?
Well, and again, you should pose that question to somebody who's actually done criminal law enforcement, not to me. But if you talk to law enforcement officials, whether from local police, from the FBI, and others, there are very clear guidelines as to how to be effective in pursuing these kinds. I mean, we have an expert right here, so maybe we can ask him to comment.
That the DOJ, the guidelines did prohibit racial profiling.
The original guidelines did, yes. Well, there was separate guidance. It actually wasn't in the guidelines. There was separate guidance that was published, I think, in 2002, prohibiting.
Okay, so do you want to comment on what does work if we eliminate looking at people's race and religion?
You know, and I mean, to push back a little bit on Iliad's point that, you know, we don't know that all terrorism is Muslim men. That's actually not true. You know, first of all, it's not true. It's only men. Right, but that was just one terrorist attack. I mean, you know, you could look at Eric Rudolph, you could look at Tim McVeigh. You know, there are all sorts of threats to our security, and if law enforcement is focused on people who are actually threats, as opposed to 1.5 billion people, they would be much more effective. And you know, the way my investigations work, I didn't go in and arrest every neo-Nazi, or even think that, hey, if you have a neo-Nazi tattoo, you're automatically a criminal. In fact, that would have wasted a lot of my resources because most of them aren't. It's very few the number of people who will actually do harm. Even people who are complete ideologues who are Nazis or who, you know, are part of these movements, very few would actually commit an act of violence. And if we focus all of our efforts and all of these resources on those people, we'll be far more successful. And it's far better because you actually get the bad people as opposed to people whose ideas you don't like. And that's really the most important thing. And I think that's what our founders realized when they wrote the First Amendment. You know, because again, they weren't guys who were just trying to make it easy on the bad guys. They had just come through a war and wanted to set up a government that would last. And they knew that if we protect these rights, there'll be less of an interest in attacking this government.
Yes. Gentleman here.
Yeah, I'm Ed Spanos from Executive Intelligence Review. This seems to be one of a number of areas where the current administration is trying to lock in its policies for the next administration. And that would really be true whether it's Democrat or Republican. I mean, people think, well, Democrats would come in and reverse all this. It's not that simple. And even with the best of intentions, if you think back to the Clinton administration coming in, how, you know, it takes a long time to get your arms around the bureaucracy, and especially the career professionals in the Justice Department. Janet Reno she got hit with Waco, and they ran circles around her. So the idea that this could suddenly be reversed with somebody coming in, you know, on a mission that we're going to change everything, is kind of an illusion, I think. But I'd like you to address, and even who wants to, the question of once these policies are in there and institutionalized, the difficulties of then trying to reverse them with the new administration.
Thank you. Joe, do you want to take a stab?
Well, sure. We are concerned about the timing, and that's one of the issues that was raised by the senators with the Justice Department. This is a process apparently that began over 18 months ago of taking a second look at the 2002 revisions. And, you know, I don't want to question anyone's motives or impugn anyone's motives, but the fact that it is coming on the tail end of the administration is of concern to us. And I think there's a sense that if we were to wait until a new administration, that this is a process that would have more buy-in and more credibility. And so I think that certainly would be our preference. In terms of undoing what might be done in the next several months, it's certainly within the authority of a new Justice Department. I tend to agree that it probably would not happen immediately, just because, as you said, a new administration has so many issues to grapple with, and frankly, it would probably take some time before they got around to considering this. So I agree that's a concern, and I think it probably would take some time.
If I can just maybe build on part of the question and direct this to you, Mike, something we talked about before, but to the extent that this is part, I want to ask you to speak to the extent to which these FBI guidelines are part of a broader trend, again, consistent with the questioner, about locking in particular law enforcement policies. And I wonder if you could speak specifically to federal regulations regarding state and local enforcement and what parallels there may be there with the FBI guidelines.
Right. I mean, one of the things we're concerned about is the same thing, but it's not just these guidelines. Again, these guidelines are a number of different guidelines. But there's also been a recent change in Executive Order 12333, which governs intelligence activities. There was a proposed rule to amend 28 Code of Federal Regulations, Part 23, which governs how state and local law enforcement criminal intelligence systems can be utilized. So, all of these authorities work in tandem with one another. So when you change one, you're actually changing all of them. And these all are, as you said, very recent and very at the close of the administration. One of the concerns I have, and it came somewhat out of some of the statements that Mukasey has said, where he seemed to suggest that these are authorities we already have, these are types of activities we're already engaged in, and that's really what's problematic to me, is how much of this is an effort to sort of authorize what they've actually been doing that is arguably in violation of these guidelines. But, basically, if you look at the bulk of what all these different authorities are doing, they're vastly changing the types of activities that both federal and state and local law enforcement officers are engaging in as far as a domestic intelligence collection activity, not for law enforcement purposes. And I think that's very dangerous in a democratic country.
Good question in back. Yes. Just wait for the microphone, sorry.
Marianne McGrail. I've accepted a position with the National Security Division of the DOJ. I wanted to go back to something that Mr. German remarked on that was very startling to me, and that is the 87%. My overall question, let me state the general question, is how effective generally are the guidelines simply? It seems like enforcement is an important component here, and given the statistics, Mr. German, that you quoted, so much appears to depend on the individual discretion of FBI agents in this case. Really, how much clout do the guidelines have they had, will they have? And this is for all the panelists. I don't mean to focus yet again on Mr. German.
And I think that's a great point. And again, that statistic, just so everybody knows what I'm talking about, is in the Inspector General's 2005 audit of compliance with Attorney General guidelines, and it regards the confidential informant guidelines, particularly rather than the investigative guidelines. But that's where we are, where because after COINTELPRO and all those abuses, Congress did elect to let the executive branch create its own internal guidelines rather than imposing guidelines upon it. It allows them to regulate themselves. And of course, in a government that's built on a system of checks and balances, that's pretty dangerous. And if we look at other areas, such as the National Security Letter Authority, we can see that internal guidance is not very effective, and that in fact congressional oversight and strict bright lines where there are serious punishments for violating, as opposed to what I've often called a secret spanking. That if an agent engages in some sort of illegal improper activity, I'll say not illegal necessarily, in the intelligence community, that gets referred to the President's Intelligence Oversight Board, and there's a secret spanking. You think, there was a Washington Post story that they actually didn't meet for the first 6 years of the Bush administration, so how effective even that internal system was is in doubt. But unless there's outside checks and balances and public accountability for these powers, we don't know what our government's doing, and that undermines their ultimate goal, which, as was well expressed here, is making sure the public has confidence in what they're doing.
Just to be clear, I'm going to quote two sentences from Mukasey's speech, because I think we're getting a little confused about what these new changes are going to do. He says, quote, "They will not alter the previous departmental rules that forbid predicating investigations simply based on somebody's race, religion, or exercise of First Amendment rights. The guidelines will require all activities to have a valid purpose and will require the FBI to carry them out in conformity with the Constitution and all applicable statutes, executive orders, and DOJ regulations and policies." So the guidelines, I mean, this is like an employee manual. At least for an outsider, this is what it seems like. It's not a DOJ regulation. There's not a notice and comment rulemaking to it. It's not a statute. It's not an executive order or anything like that. It's the Attorney General, in consultation, development with his advisors, putting out a new employee manual for his department for whatever that is worth.
And I would just push back on that a little bit, because this is an agency that can take away your liberty. So their employee manual is a little more important than most of ours in the room here. And second, I would point to that statement as sort of part of the verbal jujitsu that he used in that statement, that Attorney General McCasey used in that statement, where he says, no investigation will be based solely on race. That's not what the prohibition was. The prohibition was using race as a factor. Of course, no FBI agent, racial profiling is not opening investigations based solely on race. That's racism. Racial profiling is using race as a factor in making law enforcement decisions. That's what was prohibited. And his amending the language that way in his statement troubles me, because it seems to create in the public knowledge that there is something different between those two. And that's a very important distinction that I think we need to keep in there.
Over here.
Hi, I'm Laura Jakes Jordan. I'm with the Associated Press. I'm wondering, for those of you who have been studying this, kind of a detail on the guidelines themselves, if you've seen any specific indication that the guidelines would let rules that currently exist for foreign-based investigations or predication to be used for domestic investigations, if that's one way they're going to harmonize the guidelines, these three existing sets of guidelines. And if so, what kind of practical impact is that going to have in litigation, for due process, for the court system, criminal justice system in general? Thanks.
I guess this is me, right? Yeah, it's a good question. And one of the things that I should note about these briefings that we received is that we were, when we entered, given a copy of the guidelines that we were required to return as we left. So we didn't spend a whole lot of time with them. And that's a question I'd probably have to think about a little bit. I mean, I will say that, in general, that the harmonization that has been referred to, the general theme of that was lowering the bar, making techniques that were available in one context but not necessarily in another, available in all contexts. And so, for example, long-term physical surveillance, which some aspects of which had been permissible in the use of assessments under the 2002 guidelines under the criminal guidelines is now available in the national security guidelines. But I don't want to. I'm not sure I can respond specifically to your question beyond that. And by the way, this is the woman who broke the story about the guidelines. First we learned about it, and led to the questioning of the Attorney General, which I think ultimately led to our getting a briefing. So it shows you the importance of the press.
I just have a quick follow-up. Do you remember the date of the draft of the guidelines you saw when you saw them?
I don't. Yeah. Sorry. Shows you the efficacy of congressional oversight.
Yes, over here, please.
Hi, my name is William Krause, and I'm with the Congressional Research Service. And I'm just curious to know, Mr. Zogby, if you know what the classification will be on these guidelines come October 1.
Yes, my understanding they're unclassified. I wouldn't be here today if it were anything different than that. There is, I believe, one small section of them that is going to remain classified, but what we saw was the unclassified portion, and my understanding is that is the bulk of the guidelines, the vast majority of them.
But there will be some other section.
I believe there is a classified annex.
So we're in the back of the room, and then front, and then there.
Hi, I'm Sue Udruth, the Defending Dissent Foundation, and I have a question for you, Mr. Zogby. How strong is the will in Congress this month for challenging the FBI and for challenging? It does seem like Mukasey's been quoted a couple of times as saying, "Oh, no, race won't be the sole thing we look at to open up an investigation." So it does seem pretty clear that that's going to be a change in the guidelines, and so. Senator Durbin's going to be a strong advocate. How about the rest of the members of the committee?
I think what you'll see is, if you watch the hearing on September 17th, is a lot of concern that will be expressed on the Democratic side of the aisle in particular. There may be some concern on the Republican side as well. Senator Specter, who's the ranking Republican on the committee, did join a letter with the chairman expressing some concerns about the process in particular. And so I think that the hearing will be, with Director Mueller, will probably be a healthy debate, somewhat contentious maybe. I think it's important to note that this is an authority that the Justice Department has to exercise, as I said before, and so there's ultimately not a whole lot that Congress can do to stop them if they choose to go ahead and issue the guidelines. But I do think that you will see a very healthy debate, and hopefully that will lead to some reassessment of the guidelines in a new administration, if in fact DOJ does go forward with them on October 1st. And every indication is that they plan to do so.
In front.
Hi, I'm Dane von Breikenrucker with the U.S. Bill of Rights Foundation, and my question is for Michael. As you know, what you were saying, there's blurring of the lines. In other words, you had guidelines for criminal activity investigations at one time, and then you had, intelligence gathering guidelines, and now we have national security guidelines. And you're saying they're kind of blurring in together to where now you can use the lowest standard to go after the highest risk. So being that you could trigger an investigation on somebody on a far less provocative behavior, whatever it is that draws the attention or the glare of the FBI to an individual, is that what effect does this have kind of in the deep background? I mean, do you suddenly find yourself on no-fly list? Do you find yourself being taken through secondary training? Do you find yourself that the bank is reporting to the Internal Revenue Service more often, or you find that you go into work and all of a sudden your boss is not as friendly as he used to be because maybe they got a national security letter. Maybe you don't get that job that you were looking for. I'm just worrying about the backfield effect. Is that when you trigger these investigations and they go on 90 days and they get extended, or they just go beyond 90 days without extending and all, this information gets aggregated somewhere. And eventually, it would seem to me that it would leak into some field reports having to do with maybe some investigator doing a background check on you for a job would run into these raw field reports, and it could cause you a lot of problems. So that's kind of where I'm headed, and I probably didn't bring up all of the possibilities,
Right, and, obviously I haven't been in the government for 4 years, so I don't know what they're doing with all this information, but, clearly, you look at an example as the anthrax investigation. The FBI has enormous power, and simply investigating somebody can have serious detrimental effects on, their professional life, their personal life. And that's why, opening up not just the length of time for one of these preliminary inquiries or investigations, but also the number of techniques that can be used to where, very intrusive techniques can be used long before there's any indication of actual suspicion that this person is doing something wrong, is where I think you get into all those possibilities. And, as you said, if your boss receives a national security letter about you, would that impact your professional life? I imagine it probably would. Does the FBI come in and say, well, this is a person 3 times removed from the subject that we've identified through data mining, so we don't really have any reason to believe that he's done something wrong? Of course not. They just hand you the letter. So, I think that those are real concerns, and that's something that I think it's incumbent upon Congress to rip the lid off and see how these authorities are actually being used.
Did any of these guidelines address that problem? Did any of the guidelines talk about unintended consequences of a person being investigated that ultimately turns out to be completely innocent? Is he ever notified, for instance, that he has been a subject?
And actually, to add to his question, I mean, this third bullet on the letter here talks about basically what we know as minimization procedures for U.S. persons, and that would be sort of in that area that, okay, the FBI does this year-long investigation and finds out you're completely innocent. What happens to all that information that they collected?
Mm-hmm. Yeah, that's right. I mean, there are minimization procedures that are in place now, and my understanding is that they would continue to be in place. But one of the striking things about the guidelines that we haven't had a chance to discuss is how much they don't say. And when we probed a little more deeply and asked questions about some of the things on which the guidelines were silent, we were told that they would be fleshed out by FBI policy. And that was the case with respect to a striking number of issues. And I apologize. I don't have a perfect recall at this moment as to what it said with respect to the issue that you raised. But there were a lot of issues like that that were left to FBI policy. Yeah, I mean, I think the way that our letter characterizes it is that the draft guidelines include broad information sharing provisions with few constraints, and I think that's an accurate way of characterizing it, and that applies with respect to information regarding innocent Americans, including those who are later found to have no part in any criminal activity.
So trust us. Just trust us.
I'll leave it to you, Karen.
We're just about out of time. We're going to take one more question, then we'll wrap up. So, gentleman in back, please.
Hi, my name is Jim Norman. I'm just a private researcher, writer, not a lawyer, but I do know a little bit about terrorism, and I agree with Senator Durbin's office. There is certainly reason for concern with the timing of this because the potential for abuse, and given the track record of this current administration, doesn't inspire a lot of confidence that it wouldn't be abused. But really the thrust of my question is in terms of profiling. I do know a little about terrorism, and it seems to me that we do have some basic ideas about who terrorists tend to be. They do not tend to be psychopaths. They tend to be very logical, organized, rational people. They tend to be people who have a feeling of being oppressed in some way, either by their own government or, in the case of the United States, oftentimes because we are seen as an extension of their government. Saudis, for instance, feel oppressed, and they see the United States supporting Saudi Arabia, and therefore they see us as being ones to perpetuate their feelings of oppression. So whether it's racial or whether it's politically motivated or whatever the reason may be, it seems like the idea of profiling is not inappropriate. And I'm just not sure how we can, given the changes over time, how we can limit things or how we can fit within our constitutional structures a way of profiling that's going to enable us to carry out effective investigations, whether by the CIA, the FBI, or whomever, and at the same time be true to the Constitution and not abuse potentially innocent people's rights. And I don't know who wants to address that, but open to anyone.
I defer to Mike, who's a real expert in this area, but I just briefly say that one of the things that's interesting about what you said is in a way, was sort of a behavioral profile. I mean, you described some characteristics, feeling of oppression, not a psychopath, et cetera, that it seems to me would be some useful indicators for the FBI if they were beginning an investigation. But certainly those traits, those characteristics do not pertain across entire religious and national origin groups. And I think that's, again, not an expert, but from our perspective, that's where we start to get concerned at a policy level when we start making generalizations about that, and you're going to start missing some of the people that you ought to be looking at, and probably looking at some people that you ought not be looking at, and maybe wasting some time and alienating people at the same time whose cooperation you need.
And, if you look at where people have done empirical studies of terrorism, or they've actually looked at the people who are they've universally found that there is no profile. And The Guardian just released a story about a MI5 study that said, marginalization and racism are really the two factors that are involved. So if we respond by marginalizing people and treating them unfairly because of their race, we're actually increasing the types of grievances that you talked about, and our long-term strategy is catastrophic because it's going to increase the amount of unrest out there.
Well, still, you look at comparative terrorism acts by Alaska separatists versus young middle-class Saudis. There are certain things that are, we have to face certain realities, why ever they arose.
I get this quite a bit, and that is one type of threat. And if you actually study who it is doing it, you find it's very much different than what we generally quote know in our common knowledge. And all you have to do is look at the 1967 film, The Battle of Algiers, where the French colonial forces started searching all Muslim men coming out of the Casbah area, so they dressed up their women as, French colonial women to look Western so that they could go through the checkpoints. This is a technique that's used. They want you to form a profile because then they know how to send the next person. And, we've seen, I think there was a Belgian woman who was a suicide bomber in Iraq. We've seen, Adam Gadon is on the FBI's wanted list. John Walker Lind. What we have as our, quote, common knowledge of who the terrorists are isn't actually true when you get down to the empirical level in the first place. And in the second place, if we would be having this panel in 1996, we wouldn't be talking about Islamic terrorism. We'd be talking about militia terrorism.
If John Walker Lind had converted to Buddhism like a lot of people in the San Francisco area, we wouldn't be talking about him.
Actually, there is a lot of suicide terrorism is conducted by Buddhists in Sri Lanka. There is all kinds of terrorism. It's the behavior that we have a concern with, not the religion, not the ideology. If we focus on the behavior as government actors, we'll be far more likely to stop the people who are actually doing bad things rather than people who we simply disagree with.
I'm so glad I didn't cut things off 5 minutes ago, because I think this was as illuminating an exchange in helping us understand both the complexity and the real political and historical significance of the issues that we've been grappling with and that we'll continue to. I want to thank the American Constitution Society for convening this event and for bringing together this group for this conversation. I want to thank the panelists for their terrific presentations, and I want to thank all of you for coming, asking questions, and hopefully taking away some information that will be of use to you as you go forward in your lives and in your work. And with that, we will bring things to a close. Thank you very much.